Welcome everyone. My name is Michel Van Bellinghen. I'm a BEREC Chair 2021, the body of European regulators for electronic communications. And it is a great pleasure for me to welcome you to today's workshop on Digital Markets Act, with a clear focus on the aspects of end-users protection. We organize this workshop as end-user protection is one of our main areas of interest and is at the heart of what we do. BEREC and its honorary members work since a long time on all kinds of end protection measures in the electronic communications sector. You might remember that BEREC issued an opinion on the draft Digital Markets Act a couple of months ago, in which we make a proposal for a swift, effective and future-proof digital markets regulation. And in my view, regulatory action on digital markets should focus on three main issues. First, ensuring contestability by promoting inter-platform competition. Second, ensuring fairness for business users. And third, protecting end users' interest from potential abuses of the intermediation power of digital gatekeepers and promoting open digital environments. BEREC's understandings of the current DMA proposals is that it is mostly addresses issues that could be observed in the relationship between the gatekeepers and their business users. However, we believe that certain end users concerned should be directly considered as well. Based on long experience in the field of electronic communications, providing end users with the tool and means to make well-informed choices is crucial for the development of alternative products and services and a fair evolution of the competition dynamics. In this slide, we consider that it's worth to take a closer look at the aspect of end-user protection, and therefore we set up this workshop. We want to hear from you and draw lessons, so include in our report that we are currently reviewing based on feedback received from different stakeholders. Today's workshop will be held in two sessions, and I'm very happy that we are being joined today by two distinguished speakers in this first part to connect us with their views. In this first session, indeed, we have invited Mrs. Inge Bernaerts, Director for Policy and Strategy at DG Comp at the European Commission, and Mr. Andreas Schwab, MEP, who also is the rapporteur for DMA at the IMCO committee. And we have also a lot of very distinguished speakers in the second session as well. This session will feature a stakeholders roundtable with consumers associations, digital rights advocacy association, representatives of platforms, as well of alternative business and technical experts. So the workshop will be concluded with a round of questions and answers. But before giving the floor to our first distinguished speakers, you will hear more from BEREC's position on the regulation of digital gatekeepers from our two co-chairs on the Markets and Economic Analysis Working Group, having prepared the BEREC opinion, my very estimated colleagues, Chiara Caccinelli and Jorge Infante. So with that, I think, Chiara, the floor is yours.
Yes, thank you very much, Michel. So I will present the key BEREC proposals on the regulation of digital gatekeepers, and there are some slides that I would like to show. So while waiting for it, we'll just start by saying that it is not new for BEREC to focus on topics related to the digital platforms and digital economy more broadly. And on top of the work that we have done on OTT services, and which started already 5 years ago, We also published a report on digital device neutrality, data economy, and they've more recently largely contributed to the debate on the Digital Markets Act. We responded to the public consultation of the EU Commission last year, and we produced an opinion on the DMA and a full report on the regulation of digital gatekeepers this year, which was also open to public consultation. The workshop that we are organizing today, together with the one that we organized on market entry at the end of April, is also aiming actually to gather input from relevant stakeholders and to make sure that the proposals that we are making are fit for purpose. And all these documents that you see now on the slides are available, publicly available, and we put a list of references on the event page, so you can find them online. As for the current work, BEREC will publish a study on consumers' behavior towards digital platforms as a means of communication in June. And we are currently also working on a report on the internet ecosystem, which will be published next year. So on the next slide, we can see in a nutshell our proposals on the DMA. Over the last years, our approach has always been to build on our experience in ex-ante regulation in a closely related sector, so the telecommunication sector, and because we believe that it can be very valuable to help shaping the regulation of digital gatekeepers as well. Our proposals are there to make the DMA swift, effective, and future-proof, as Michel was mentioning before. So first of all, we strongly welcome the DMA ambition to create fair and contestable markets. And to make them contestable, we believe that some barriers to entry must be lowered to create real conditions for competitors to arise. And we discussed this point with industry representatives in our workshop on market entry, which is also available online on the event page. And this being said, even if contestability and fairness are key objectives of the intervention towards the gatekeepers, we believe that concerns related to end users, meaning consumers, should also be directly addressed by the DMA. And these concerns, for instance, considerations on consumer behavior, their ability to make well-informed choices, and also how their choices can be affected or hampered by some practices of the gatekeeper, by instance, like by means of default settings, as an example. And we think that there is a beneficial. So sorry, I'm hearing some background noise. If it can be muted.
Danikla, if you can.
Okay. So why do we think that these issues should be addressed directly? It's because we believe that there is a beneficial circle that can be created. Because if it is true that intervention creating fair conditions for business users and potential competitors are eventually benefiting end users, of course, but this is also valid in the other way around. So empowered end users enjoying their freedom of choice and ability to access services, information, and content, and being well informed and conscious of the choices they make, will also help creating healthier competition dynamics. So this actually works in both directions. And secondly, about the enforcement. So to make the DMA ambition a reality, we believe that there are some improvements which are needed and to make this intervention swift, effective, and future-proof. So swift, what does it mean actually? It means that the results must be effective in a short time frame, and not that the intervention must happen quickly, because if it does not reach the objectives, it will finally take longer. And future-proof, meaning that the regulation is able to address the issues even when the gatekeepers' practices will evolve, because they may evolve even before this regulation comes into force. So to make it swift, we have three proposals: the regulatory dialogue, the dispute resolution mechanisms, and the national support. As an ex-ante regulators, we have learned that some measures, especially when they are highly technical, cannot be effective if they are not correctly specified and designed. And interoperability is a very good example of this, and we will discuss it quite a lot in the second roundtable. And to specify this obligation, you cannot just ask the gatekeepers, but you need to structure the regulatory dialogue with a different type of stakeholders, because it is them who can actually give the regulators very important information about what is needed. Because the gatekeeper in general has no incentive to lower these information asymmetries. So for instance, what does it mean concretely? This could mean that the gatekeepers' proposals about the specifications of the obligation is open to public consultation to get inputs from other actors. And also this need to create this regulatory dialogue is also something that we will discuss later on, because it doesn't have to be restricted to business users or potential competitors, but be larger and include consumers and civil society, for instance. So sometimes also the obligations, even if they are specified, they may not be correctly implemented by the gatekeepers, so they may not work as they should. And in these cases, it is also key to intervene fast. And that's why we propose to set up dispute resolution mechanisms to minimize the negative effects on competition dynamics and innovation. And here again, there is some experience in regulated markets that we can draw inspiration from also for the DMA. And so while the intervention should be at the EU level, and BEREC strongly supports this, we also believe that national independent authorities could support the Commission in their with their existing experience in data gathering, monitoring of markets and compliance, dispute resolution and remedies design. And again, the enforcement would be centralized at the EU level, but the national support can be very valuable to efficiently implement this very ambitious regulation. And then to make it future-proof, so meaning to allow the European Commission to intervene quickly, even if the practices change. So we believe that the European Commission should have more flexibility from the beginning. So together with the obligations, which are already in the DMA, we believe that some clear ex-ante principles should also be set in the law and allow the Commission to easily design further remedies in case the obligations are not correctly addressing the issues. And this flexibility would be on top of the obligations already listed. So we are not asking to replace these obligations, but we just ask to complement them and give the European Commission the power to adjust the intervention more easily. So for instance, an ex-ante principle could be that access to some essential inputs must be granted if it is necessary to reach the given objective of the regulation. So this would be in the law, and then it is applied on a case-by-case basis, and specified also and tailored on a case-by-case basis. And this is the way that ex-ante regulation has been enforced for over 20 years, for example, in the telecom sector. So it is something that has been tested and can also provide experience for the DMA. And finally, on the scope, we will publish in mid-June a report on the interplay between the EU Code for the Electronic Communications and the DMA, concerning number-independent interpersonal communication services, which are to be regulated under the DMA, and which are also regulated under the Telecommunication Code. And in general, we want to ensure that there is a correct interplay between these two existing regulations to protect regulatory certainty. So this is BEREC position in a nutshell, and so thank you very much for the attention.
Thank you very much, Chiara, for this comprehensive presentation of BEREC opinion. And with this, I think it's now time to listen to the views of the European Commission and to learn more about how the DMA will benefit end users' interests in their relationship with gatekeepers. And for that, we have invited Mrs. Inge Bernaerts. She is being a director for policy and strategy at DG COM since last summer, and she's one of the brains behind the Commission's proposal. Before that, Inge Bernaerts held management position in the Director General of Energy, and she also was head of cabinet of the former Commissioner Marianne Thyssen. She also worked as a case handler in antitrust and state aid and practiced competition law at the Brussels Bar. And it is a real pleasure, Inge, to have you here with us today. The floor is yours.
Thank you very much, Michel, for that warm welcome, and good afternoon to all of you. It's a pleasure to participate here in this webinar on the Digital Markets Act, and in particular, given the focus that you have put on consumers and end user benefits in the DMA. I'd start at a fairly high level, perhaps in depicting again the general context in which we are acting, a context where digital platforms play ever bigger role in our lives as citizens, as consumers. And this has been very much exacerbated by the COVID crisis that we are still living every day in terms of the digital means that we use even to attend this webinar today. We've only seen this further expansion of the role that digital platforms take in our lives, a positive role that enables us to keep going even in the midst of a pandemic, a positive role where also new and innovative services are being developed and offered to consumers. But it's also a context where these new opportunities also bring new risks. And most notably, what we observe is that very few or very small number of private undertakings, because of their control over certain key digital platforms, have grown into very powerful positions. They have become, if you like, the new gatekeepers of our times, who control the access routes to consumers, just like, if you like, gatekeepers in our medieval cities one day controlled the access roads that merchants had to travel to reach the customers in the cities every day. And that position of power of those gatekeepers, if left uncontrolled, if left unregulated, is prone to misuse. And again, like the gatekeepers in our medieval cities, today's digital gatekeepers control who comes in, under what conditions, in the form of a price to use an app store, for example, but there are also other forms of modern toll in the form of personal data, which are being made available. And these parameters, because of the very specific features of digital industry, because of the network effects notably, lead to, again, a small number of ever expanding conglomerates that in our economy, but also in our societies, have become very powerful. And those risks mean that for consumers, there is a threat of having less choice than in an optimal situation, of having to pay higher prices if merchants pass on the toll they pay at the gates to their consumers. Also a risk of more arbitrariness and less legal certainty. Now, within that context of those risks deriving directly from the specific gatekeeper positions that are being held, what does the DMA do to try to solve this issue? Well, the DMA, and I think that's important to underline, focuses very much and regulates the behavior of the gatekeepers. It is in that sense an asymmetric regulation with a very specific focus on a concrete problem. In that sense, I think it's also important to underline that the DMA is, of course, not the only regulatory instrument in the digital space. Notably, its twin proposal, the Digital Services Act, also has important complementary regulatory features to try to protect interests of users and of society more broadly. And we have existing tools as well. Think about the P2B regulation, data protection rules, of course, consumer protection rules at the EU national level, competition rules, importantly, also that will continue to apply. But the specific objective of the DMA is indeed threefold, as Michel very well underlined in his introduction. It's on the one hand to ensure that digital markets remain open and contestable despite the strong presence of gatekeepers, and by doing so to create space for competition, for innovation, and to promote inter-platform competition. So that's the first and foremost important objective of the DMA. The second one is to avoid unfair conduct by gatekeepers, both towards final consumers and towards business users. Now, the instrument that we have chosen is a regulation, a form of ex-ante regulation, whereby the do's and don'ts are set out in the legislative act itself, and they will apply automatically from the moment onwards that companies are being designated as gatekeeper. And again, I think there is a very important consumer or end user interest in this choice, because we know that it's consumers as well as business users who suffer if compliance is not ensured, and if it takes too long to guarantee compliance, in particular in these markets which tip quite easily and quite rapidly. So by creating this upfront regulation, by specifying clearly the do's and don'ts, we believe that we create not only the legal certainty, but that we also create the preventive effect of that legislation, which hopefully will avoid the behavior that is foreseen to be banned by the DMA from arising. And that effectiveness, the speed and the implementation of the DMA, that also BEREC supports in its intervention, we believe has an important protective aspect towards consumers. I won't dwell very long on the mechanism of designation of gatekeepers. I think that's perhaps not so interesting for the topic of today, but I want to zoom in for a moment on that set of obligations and prohibitions which are foreseen in the Digital Markets Act. Those are quite broad, and they range from, for example, prohibitions of parity clauses, or prohibition of the right to complain to public bodies, over prohibitions to combine user data without user consent, over an obligation to allow for pre-installed software to be deinstalled, or access to app stores at fair and non-discriminatory conditions, and so on. Now, let me take one example to illustrate how these do's and don'ts benefit consumers both directly and indirectly. And the example I wanted to touch upon is the ban on parity clauses. Well, that ban will allow competing platforms immediately to offer more favorable conditions to consumers, and that has a direct benefit to consumers. But that ban on parity clauses also means that we will stop the consolidation towards one platform that will become the dominant platform and the only platform at the end to be able to reach consumers. And it creates the possibility for the development of competing platforms, which means that consumers will be able to have more choice and a more diversified spectrum to make their decisions. Likewise, by our provisions that enable data portability or multi-homing or side loading, the DMA will offer consumers more options, more choice, which benefits them directly as well as indirectly by creating the space for competing services and products to be developed. Now, choice, that means an empowerment of consumers, but it also means that, for example, consumers are able to consent to deep profiling based on data that are gathered by gatekeepers across platforms. Now, some stakeholders would like the DMA to go further and to just ban, for example, data combinations or deep profiling. We believe that that would not be warranted, that the best way forward is to create the choice for consumers, to enable the consumer to make an informed choice, but of course taking into account also certain biases that we know exist when it comes to consumer behavior, and on how to do that best. I mean, BEREC has just mentioned a couple of suggestions. I'm sure that they're also the proposal that we put on the table could possibly be further strengthened and improved, and all ideas are welcome. And just a final word from my side on the enforcement system, because it was also mentioned, and it is an important point in BEREC's advice. We have indeed opted for a system where the DMA is enforced centrally. This is because of the DMA having a very important internal market dimension, and that internal market dimension whereby we want to create uniform rules that apply across the internal market, not only for the business users, but also for the 450 million consumers in the single market. We think it's important to make sure that those consumers can all benefit from an effectively enforced Digital Markets Act and from barriers between markets being further removed. We've chosen for a system of investigative tools that has also proven its benefits. They are copied to a large extent from the competition law system. They enable us to request for information subject to fines, but also do inspections, take statements, and so on. And there are, at the same time, we think, due process rights foreseen to guarantee that rights of defense and transparency of decision making are properly protected. Now, as I said, we put our proposal on the table in December. We are now in the process of discussing it in the Council, also in the Parliament. Mr. Schwab, I'm sure, will say more about this. As Commission, it means that we have somehow given the baby out of our hands into the hands of the co-legislators, but we continue, of course, to be there as facilitator of the discussions and hopefully not in a not too far away future also of trialogues, so that the co-legislators can come to a political agreement and that the Digital Markets Act can enter into force as quickly as possible. But as was underlined by BEREC, of course, it's not only a matter of speed, it's also a matter of quality. And our main focus is therefore to continue making sure that the DMA is ambitious, but also that it's effective and that it can be enforced efficiently. Thank you very much, Michel, again for having me. And I hand over back to you.
Thank you very much, Inge, for this very clear overview of end users protection measure within the DMA proposal. And now, after hearing the Commission's view, I think that we are all curious to hear what the European Parliament has to say about that. And it is a real honor for us to have with us MEP Mr. Andreas Schwab, the rapporteur of the DMA within the IMCO committee. Mr. Schwab is also a lawyer by training, and after his first election to the Parliament in 2004, he soon became a heavyweight as he has been steering key legislation on competition policy, consumer rights, services, and cybersecurity. Mr. Schwab, the floor is yours.
Thank you so much, Chairman. Ladies and gentlemen, thank you for your invitation to today's conference in the context of the BEREC Workshop. How could the DMA proposal better protect, empower end users? It's my pleasure to give you an overview about a certain number of elements that from the side of the European Parliament seem to be of utmost importance. And thereby I will not repeat what Inge Bernaerts has said already on the content of the law. Just this, it was the European Parliament's Internal Market Committee that has already in 2014 asked the Commission with the resolution that has been adopted by a large majority in the plenary to look for ways to make sure that in some areas of gatekeepers there is a tougher application of EU rules needed. And it has taken now 7 years for this to happen. It has taken a lot of procedures at DG Competition to try to fix the shortcomings of the decisions that they have done before. And therefore, for me personally, there is a real need to get this better and to make things working seriously in the internal market of the European Union. Speaking about the internal market of the European Union, at least for observers that are not well known to this, like the BEREC people, Mr. Van Bellinghen, means or could mean sometimes that we are having a protectionist approach, but we don't. We were getting known to these problems, ladies and gentlemen, by American companies, by the users and by the gatekeepers themselves, because the conflict between distribution and supply on the one side and the small doors of the gatekeepers on the other side is not a European problem. If you take the seats, the establishments of the companies concerned, it's an American problem. If to take the users of these companies, it's a global problem. And therefore, we are fixing at European level something which is not yet fixed in the United States market, nor at global market level. Therefore, we want to do the utmost in the Internal Market Committee to make that law a reality as soon as possible. And our aim is to make a trialogue concluding under French presidency at the beginning of next year. That means that the consideration of the draft report at the moment is foreseen on the 21st of June. But as there are other committees involved, we have to fight and to look for them to have the same approach, so that the law will not be adopted only in 2024, just before the Parliament will be going for election. That means that before the summer there will be amendments, and the amendments will be discussed at the end of September, and we hope that we can vote in the plenary in December. So quite an ambitious timetable, especially after COVID has also jeopardized a bit procedures within the European Parliament, but still that's our aim. Now, as the representative of the European Commission has already outlined a lot, I won't bother you with too much elements on why Article 114 is the right basis, because we have regulatory fragmentation. We have elements that are at the edge of competition policy with other elements of internal market legislation. And therefore, we have to make sure that we keep our single market in the best shape possible. I believe that if we do this law now, we have to be very focused. We cannot look for everything here. This has to be very concentrated, and therefore I think we have to shape a bit better the structure of Article 3 by making clear that the European Commission is obliged to look for the biggest companies of the world. That doesn't mean that there might be other companies coming up, emerging soon, but for the time being, it's a question on the biggest ones. And we have also to reassure all small companies in the US and Europe that the European Commission will not investigate now into them, but they will look for the gatekeepers and look for the behaviors that are fixed in Article 5 and 6, the famous do's and don'ts. They are going beyond what we have already been legislating in the last term on the platform to business regulation. And for them to be really efficient, we need an approach which could be called the carrot and the stick approach. I can permit myself to a bit more provocative in my wording than the representative of the European Commission. What could be the carrot? The carrot is the dialogue that the European Commission is having with gatekeepers for some months. 6 months is surely too much. It should be shorter, but there can be a carrot if they come to an agreement quickly. But we have to make sure that the procedure is tough. And Michel, you know very well, with BEREC, you have some experience on how to be tough. But we have also the stick approach, which is the systemic non-compliance in Article 16. And here the Commission has to be in a very, very strong position to make sure that if they have been discovering behaviors of non-compliance, they really act, and they act with strength. The key question in the end will be, because I don't want to speak for too long, I know that you're interested in also the questions around the procedure. The definition of the gatekeepers has, as I told you already, quantitative and qualitative elements. And I believe that we should most of all focus on the qualitative elements for the European Commission to make a decision. And for this to be achieved, they can for sure take the presumption that we will offer to them. But the presumption is nothing else than a presumption in the end. It's up to the Commission to apply the qualitative arguments. And like that, they are a bit more flexible. This flexibility for sure raises some questions of how can this be enforced by authorities? And because there is no doubt that the enforcement in the past has been done with DG Comp and the national competition authorities that have quite an experience about how to cooperate formally, but also informally. But it's also true that the results with the so far known competition policy cases are not really satisfying. For that reason, we have this proposal, and we have now to see how we can enforce it differently. I know that BEREC, and you have mentioned it, Michel, has quite a long experience with applying telecom rules for the telecom market. And like that, you have a long experience on how to apply regulation and how to work ex ante with companies so that the market can work. That gives you an experience that other authorities don't have. And in addition, there is the element of a need to make sure that those administrative or state or EU units that apply the DMA, even though this DMA will be fixed and legislated by the European Parliament, but still it will keep a certain flexibility for the authority, that this authority that applies this law is not the same authority that goes beyond companies that have been not sticking to the rules in 101 and 102 of the treaty. I mean, it would be maybe a bit too far-reaching to say that there is a need for separation of powers, but in any event, you need a very clear enforcement structure. And therefore, we are still in discussions, ladies and gentlemen, on how to get that right, how to make sure that key principles, fundamental rights in the European Union are respected, but at the same time that we get the smoothest tool available to fix the problems as quickly as possible. Because in the end, these gatekeepers, for sure, as Inge Bernaerts has mentioned, have brought innovation, but we don't know now how much innovation they have been stopping by buying companies that wanted to bring innovation, but have been caught by killer acquisitions. We don't know how competition is boosted by these companies. We see the really outstanding prices and the extreme delivery capabilities of companies like Amazon, but we don't know what the prices would look like without them. So we are a bit in doubts, and that is for sure the best that we can do because we don't know. So therefore, with that law, we want to do the best what we know now, and that is that we have to improve transparency, that we have to improve the procedures, and that we have to open up again those elements in our economy where the gatekeepers are at the moment blocking further developments. So we help not only our society and plenty of our companies, plenty of our consumers, plenty of our workers, our whole societies are a bit caught by these companies. But therefore, we would also give competition tools that are urgently needed to the companies within these conglomerates of gatekeepers, but also outside to make our digital single market working better again. That's the aim we have. And if you can contribute to this, you are more than welcome. Thank you so much for your attention.
Thank you so much, Andreas, for having shared with us your carrot and stick approach, but also your ambition to have this effective enforcement. We could not agree more, of course. So, ladies and gentlemen, dear colleagues, we have come to the end of the first session, and this sets the scenes for the stakeholders we have invited today to share their views. Our two co-chairs of the BEREC Market and Economic Analysis Working Group, Jorge and Chiara, will take it from here. So, Jorge, may I ask you to introduce today's speakers for the second session. Thank you very much for your attention.
Thank you, Michel. Just before entering to the second part, we have a question here in the chat for Inge. So I don't know if we should address it now or to put it to Inge or to start depending on...
It's up to Inge. If Inge would like to take one question. Inge?
I'm certainly fine to take one question. I unfortunately have to leave in about 5 minutes, but I can take one
Let's
question.
do it now then. Thank you very much.
Okay, so Inge, I don't know if you can see it in the chat, but I will read in any case. It's from Frederick de Backer from Telefonica, and he asks that if a citizen, an end user, has a complaint against a gatekeeper, has he to call the European Commission or can he find help in his member state? This is the question. Is how to
I think there are certainly different channels available to that citizen. First of all, the idea is also that the provisions of the Digital Markets Act are made so precise and are directly applicable, that they can also be enforced in national jurisdictions, so that there the normal instruments are available as well. Now we know that for citizens that's not always easy, and that also can sometimes be costly to do that litigation, but that's why also the public enforcement instrument is there. And it's not because the Commission has the sole power under our proposal of DMA to take decisions that in terms of ears and eyes on the ground, as I always call it, we would not be actively relying on the network of authorities and bodies that exist in the member states, as we also do already today, be it my colleagues from DG Connect or me and my colleagues in DG Competition. So for sure, in terms of having our ears and eyes on the ground and to catch the problematic behaviors, we should continue to use intensely those networks as well. And there is a provision in the draft DMA that precisely foresees for that type of cooperation, whether then those national bodies would already do a first preliminary investigation and then hand that over to the Commission, or whether they immediately pass it on for investigation by the Commission, is, I think, something to be discussed and spelled out in more detail. But that network should be actively used is very clear to me.
Thank you very much, Inge. And thank you also very much to all the speakers in the first session, Andreas, Michel, and Inge. And without delay, we move to the second part, that it's a round table with representatives of relevant associations and experts, following that idea on the dialogue to be taken with all actors that BEREC is promoting. So the idea is to hear directly from them on their views on different topics you have seen in the agenda, on what are the consequences of gatekeepers' dominance on for foreign users' interests, the adequacy of the DMA to empower and protect end users, and how it can be improved over any proposal or idea. And last, on the role that national and European authorities can play to enforce and to use appropriate tools to empower and protect end users. So for that, we have with us 6 experts representing different associations or directly expert views, and the idea is that there will be a short intervention from each of them, and then we will start on the dialogue and discussion with questions, answers. Just to remind you all that you can put your questions in the tool, and we will take it and redirect to the ones participating. So as a very short presentation on them, because they will present their organizations, we have Vanessa Turner, who is a senior advisor on competition for the European Consumer Organization, BEUC, representing 45 independent national consumer associations. We have also with us Kay Gebeli, that is Competition and Regulatory Council to the Computer and Communications Industry Association, CCA. Maria Luisa Stasin, who is a Senior Legal Officer at Article 19, and Maria Luisa will explain, but Article 19 is focused on freedom of expression and freedom to know. And as a technical expert, we have also the pleasure to have with us Ian Brown, who is an independent consultant and visiting professor at the Fundação Getúlio Vargas Law School at Rio de Janeiro. We have also Christoph Schmon, who is the International Policy Director at the Electronic Frontier Foundation. And finally, we have also with us Anna Mascal, who is the EU policy advisor at Wikimedia in Germany. So we have a good panel with different views and options, and without delay, we start hearing and learning from them, starting with Vanessa. Thank you to you all for joining us and sharing your opinions, views, and ideas. So Vanessa, the floor is yours.
So thank you very much for the opportunity to participate today. As Jorge mentioned, I'm speaking on behalf of BEREC, the European Consumer Organisation, which represents independent national consumer organisations throughout Europe, in fact, in the 27 member states and some neighbouring countries. So our main role is to represent our members to the European institutions and to defend the interests of consumers, European consumers. So this naturally includes digital markets and hence our interest in the DMA. So I should start by saying that BEREC strongly welcomes the proposed Digital Markets Act. We think it's a very good starting point to tackle problems in digital markets that can harm end users or consumers, as we would probably say, and which other types of law, such as competition law, consumer protection law alone, have not been able to achieve effectively enough. So having said that, although we think it's a good start, we also think that to ensure that the final DMA optimally serves end users, the proposal must be strengthened by the co-legislators to deal with a number of end user concerns. But before I go into what we believe needs to be improved from the end user perspective, let me first underline what we think it is essential to maintain in the proposal. If we want the DMA to have an impact for end users, it's vital that it remains based on the proposed approach of self-executing obligations. And some, in particular gatekeepers, argue for a more case-by-case or so-called principles-based or flexible approach. In reality, this is a weakened approach. We would urge the co-legislators to ensure that the DMA is not weakened in this way. One of its main advantages as currently proposed, and as Inge actually indicated just now, is that it deals upfront with problematic conduct of gatekeepers, rather than allowing lawyers to argue for years about what is or is not problematic, as is the case today under competition law. So to retain a key end user benefit of the DMA over other legal tools, it is essential that we stick with the current ex ante self-executing rules approach and not allow this to be watered down. Turning now to where we think the proposal needs to be improved, for us, there are two main end user angles. There is currently insufficient focus on, firstly, end user interests, and secondly, the role that end users will play in making the DMA effective in practice. So starting with end user interests, here there's a lack of focus both from a substantive and a procedural perspective. Substantively, as other speakers have said, the DMA is built on the twin objectives of contestability and fairness. However, the current proposal is heavily centered on contestability and fairness for business users rather than end users. End users are named as beneficiaries of the gatekeeper obligations in only 7 out of the 18 obligations and prohibitions in Articles 5 and 6. And while I would agree with Inge that end users will also have indirect benefits from more competition and more choice from the other provisions, there is nevertheless a need to reflect end users' interest directly in further articles. So one good example of this is the proposed Article 6.1f on interoperability. This article only provides for interoperability between core platform services and business users' ancillary services. It does not enable competing core platform services to develop for end users. So in other words, this article would therefore do nothing for genuine end user choice in core platform services, in core platform communication services. By that I mean social network and instant messaging services. So the current DMA proposal ignores consumer choice and contestability and fairness in these important digital services. Here, the fix would be to add a new article requiring gatekeepers to offer interoperability for these services. So turning now quickly to procedural issues from the end user perspective, and others have touched upon this, but Article 30 of the DMA currently provides only gatekeepers with the right to be heard before the Commission adopts a decision in multiple types of proceedings under the DMA, such as the scope of the Article 6 obligations, market investigations, non-compliance, and so on. End users, and indeed other third parties, interested third parties, must have the right to be heard before such compliance or enforcement decisions are taken, when their interests can be affected by these decisions, as BEREC has also said in its papers. If the regulatory dialogue on compliance with a particular obligation only takes the gatekeeper into account and not the intended third-party beneficiaries of the obligations, the chances of effectively achieving the objectives of the relevant obligation in practice are likely to be materially reduced. The incentive of the gatekeeper will be to preserve its existing practices and not to promote contestability. So without the ability to check, using the expertise of third parties in the sector, that what the gatekeeper proposes will actually work for those that it's intended to benefit, the DMA may miss its aims, and that would not be in end users' interests. Switching now to the second lack of end user focus, the role that end users will play in making the DMA effective in practice. The DMA currently concentrates on technical or contractual obligations on gatekeepers. For example, in relation to end user rights to install or uninstall or switch apps or consent to data combination, or not be tied to taking more than only the gatekeeper product you want. That's good insofar as it goes, but it ignores the other side of digital transactions, and which has actually been mentioned by the speakers, which I'm very pleased to hear. And by this I mean how end users will react, or rather can be steered or manipulated to react to what the gatekeeper proposes. To make gatekeeper obligations work in reality, it's important, first, the DMA recognises the power of default settings and the right of end users to change them. Second, and more broadly, it is essential that the DMA's anti-circumvention provision, and I mean Article 11, is strengthened to include a prohibition on presenting end user choices in a non-neutral manner, or otherwise influencing or impairing end user decision making through the gatekeeper's user interface. This is the type of conduct that some people call dark patterns. Such tactics can be just as effective as technical or contractual barriers. Just think how often you have clicked accept all cookies, even if you don't actually want to do that, but you just don't have the time or the energy to go through the potentially hidden multiple steps to make a different choice. Such techniques must be explicitly prohibited in the anti-circumvention provision. Otherwise, the success of the DMA risks being seriously undermined. As a final point from the end user perspective, like BEREC, we believe that the system of enforcement in the DMA needs to be made more effective, and this in terms of procedures, in particular legally binding deadlines, in terms of effective sanctions from the first infringement by a gatekeeper under Article 25, and in ensuring that the regulator, and we also think that this should be the Commission, but with sufficient resources, which could potentially involve member states authorities, as others have suggested. Lastly, the DMA must be enforceable in member states' courts, including through representative actions by consumers to obtain redress. So in the interest of time, I won't expand any of these points now, but I'm sure that we'll come back to them on the discussion later. Thank you.
Thank you very much, Vanessa. You have raised a lot of ideas, so later on we will have time to exchange different. So I give the floor now to Kay Jevali, and the floor is yours from the CCA.
Thank you, Jorge, and thank you again to everyone in the audience and for the great organization of BEREC. I am speaking on behalf of CCIA, which represents a wide range of European and international technology companies that will be affected by the rules of the proposed DMA, not just the big platforms, but also smaller ones and all the companies that rely on the technologies of the platforms. We at CCIA have been fighting for nearly 50 years for digital markets where all competitors have a fair chance to succeed on their merit. And if for that objective, we support the DMA, and we support a DMA that would be more flexible and effects-based so that it can preserve value creation, growth, and competitiveness of Europe's digital economy. And I want to start really with this question of how can the DMA protect end users in the future if the regulation doesn't look at the effects on end users. If we take a step back and look at the context, how have these gatekeeper companies become successful? One has a mission to be Earth's most customer-centric company. One is to give power to the people to build community. One is to organize the world's information and make it universally accessible and useful. And another is to bring the best user experience to its customers through innovative hardware, software, and services that just work seamlessly. Are these companies failing in their consumer-centric objectives? No, these companies continue to innovate and create incredible new products and services for users, business users, and consumers, and some of which were once science fiction. Amazon has created a one-day delivery network that has been the lifeblood of many businesses and a great benefit for end users during this pandemic. Facebook has created cutting-edge virtual reality technology that is affordable and accessible more than ever imagined. Alphabet is creating automated driving technology that will transform mobility in our cities, alongside a number of other moonshots that they're engaged in. So let's not break what is working just to satisfy the interests of some business users, which is really the focus of the DMA. We think a more flexible and effects-based approach would create a safe harbor to preserve this kind of pro-competitive conduct that benefits end users. Now, we know the market power of these platforms is in large part due to their aggregation of consumer demand and how that creates competition between suppliers on the marketplaces they have created. Competition on the platform means that the largest suppliers now face competitive pressure from millions of SMEs. Digital companies have empowered SMEs in this way and empowered creators by removing the old gatekeepers of local geographically bounded markets. Today's digital markets aren't geographically bounded, they're global. Thanks to technology lowering entry barriers, creators only need 1,000 true fans to make a business, to make a living, to be successful. This has caused a Cambrian explosion of content and choice. The same is true in other industries. This is good for creators. It's amazing for end users. The DMA proposal threatens to shift the balance of power back to the very large businesses that used to control these local geographic distributional monopolies and oligopolies. That's not to say a DMA isn't needed. Don't get me wrong. There are definitely issues of enforcement speed and information asymmetries that need to be addressed. But a more flexible and effects-based approach would help the Commission better understand the market dynamics and the actual impact of its interventions, ensuring better decision-making in the future. As many national regulators have pointed out in their consultation submissions, sound knowledge and detailed understanding of the business models and technicalities of the sectors needs to be built in. This is especially true in highly dynamic digital sectors. We want a DMA that strengthens the platform economy, not punishes it, because believe it or not, the interests of end users and platforms are aligned. A more flexible and effects-based approach would designate to gatekeepers the specific obligations that are relevant to them in context and in light of their likely effects. But the proposed DMA imposes a series of catch-all obligations on all platform businesses based on competition law disputes between giant multinational corporations. It imposes these obligations out of context and without regard for the effects they will have on end users. The DMA would grant broad discretionary power to a Commission enforcer to determine ad hoc what is fair and what is unfair for business users, without any assessment of the effects on end users. It is a subjective judgment on business models and technical designs, not an objective one. This kind of Commission power demands reasonable safeguards. A more flexible and effects-based approach would consider the possible justifications for the conduct otherwise prohibited, looking at substantiated positive effects, not speculative ones. Such an approach could then also consider wider harms than those that are currently covered by the DMA, while also giving the gatekeepers the right to defend their decisions when substantiated for pro-competitive and pro-innovation and pro-consumer reasons. This would be more objective and would provide more legal certainty. I know many here are concerned about the use of data and the long-term implications of this, but not all companies use data in the exact same way in all their core platform services. We need to look more closely at the effects of the DMA provisions in context. The DMA is a very blunt instrument. It doesn't let the Commission go after specific harms that it could identify in the future. It only advances the interests of business users, and we think that has significant risks for end users. It also carries risks for the wider European digital economy. The Commission's impact assessment assumes that there will be no negative effect on non-gatekeeper companies, on consumers, or on the business users who aren't involved in these giant competition cases. The Commission makes a very bold assumption here. There are a number of concerns with this. Even the Regulatory Scrutiny Board has raised some of these. I want to focus on three in particular. One, nobody knows what the actual economic impact will be. The Commission's impact assessment does not look at the effects of the obligations, and the Commission's specifications of obligations don't look at the effects either. For market regulation, this lack of any analysis of effects is surprising. Two, breaking up big tech's tools and services in Europe will harm all the other players who use them, including many of our members. It will make European companies less competitive, especially the smaller ones, who leverage the benefits of the platform services to compete with large businesses. It will make European companies less competitive. This means lower quality services for end users. Three, all the smaller platforms that use the same strategies to grow will be discouraged from doing so in Europe. Prohibiting this conduct is unfair without looking at the effects raises lots of these kinds of questions. As I've said earlier, it's a moral judgment on business models and technical designs, not an objective economic one. I think we need to look at what will affect consumers and the accessibility of the best and cheapest digital tools and services in Europe. All these problems can be solved really with one simple fix. The Commission should be required to further specify the obligations in light of the effects on consumers and end users in context. That's it. This will help the DMA preserve value creation, growth, and competitiveness in Europe's digital economy for the benefit of end users and consumers. Other jurisdictions like the UK and Germany are following this effects-based approach, and we think that doing the same here is the best way to safeguard the interests of end users. Thank you.
Thank you very much, Kay. I think that we will have an interesting debate later on, seeing different views, and thank you for that high-level view. So, to have another different perspective, we have with us Maria Luisa Stasi from Article 19, and the floor is yours, Maria Luisa.
Thank you. Thank you very much. And thank you for the invitation. It's a pleasure to be here. And it's a pleasure especially to have the possibility to share my views, but also to listen to others and have this sort of conversation. I have to say it's also a privilege not to be the first, but to come after such a great intervention so that I can pick up points, try to react, and if possible, just find my little niche of things that I could share with you. So first of all, Article 19, it's a free speech organization. So what we do, we try to defend freedom of expression and right to information in different areas of the world through different kind of projects. We do a lot of policy and advocacy work, especially, but not only in Europe. We do deal with the offline world, but also on the online environment. So the question might be why a free speech organization is interested in the DMA. The answer, to be honest, is pretty simple. It's because the majority of digital markets we're talking about and the DMA deals with are key components of the our today communication infrastructure. So because of that, they're also one of the main places where we can communicate with friends, colleagues, families, etc., where we can access information, share information, and so on and so forth. So they're the main space where we can exercise our free expression rights. This is the main reason. We don't focus. So the second question might be why we care about how the markets are structured rather than how the services in those markets are provided. The typical example is social media markets, free speech organizations. They usually are extremely interested about how content moderation is regulated and as a service and so on and so forth. Well, this is true and is an essential component. It is obvious that we need content moderation rules that comply with international standards, but this is only part of the story. If we forget to look at the markets, then we're not going to be able to address some challenges that are fundamental challenges for end users, but I would say for the entire society in a way. So this is why we try to keep an eye on both sides, and we're definitely convinced that the fact that the European Commission has issued the two proposals, the DSA and the DMA together, is very welcomed, and we strongly support negotiations at the Parliament and at the Council to go as in parallel as possible, because synergies needs to be absolutely exploited among the two instruments if we want to achieve our objectives. So I said that there are some markets features and challenges that do impact and do impact on the way we express our ideas, the way we access information, etc. So they do matter for end users' rights, specifically free expression, but not only, of course. We talk about highly concentrated market. Now, I don't need to repeat what has been already explained by the previous speakers, of course. Just to focus on a couple of points. High concentration in those markets, it means that we have one or a few players with an enormous power on main channels for communication in society. So the first question is this only an economic problem? Of course not. And this is the first this is the first reason why we welcome the DMA, because it does shift the focus from purely competition objective to other legitimate interests. So this is, for us, is absolutely a welcome step, and I need to echo my co-panelist that said that before, especially Vanessa. The point is are those legal interests protected enough? And this is the DMA doing enough? Now, contestability could be read, we like to interpret that, as a reference to a sort of decentralization of power. If you open up the market, if you have more competition, you have more players, you have more choices for end users, which means power is less concentrated. You have decentralization, which is something that we absolutely welcome, and we think it should be key in the way we imagine the markets, our communication markets of today and tomorrow, possibly. The second point is fairness. Now, fairness, if it's looked, the second legal interest protected by the DMA is fairness. Looked from an end user perspective, fairness, it's in looking at a specific context, core platform services and end users, what we have is fairness in intermediation. Fairness, again, I need to stress this because I think it's important, and I think it's the added value I can bring as Article 19. We're talking about fairness of intermediation in communication markets, or at least in markets that are essential that are components of our communication infrastructure. So we're not talking about any market. We're talking of something that has a specific role in society. So that's why we are extremely interested in having this fairness interpreted as a wide concept that takes into account not only, for example, the idea of what can be an economic impact of a specific rule that intervenes and tries to ensure this fairness, but also what could be other kind of consequences and impacts on society and on end users' rights and interests. The other point is also because of the legal interest the DMA protects, so contestability / decentralization, if we want to force this kind of interpretation, and then on the other side, fairness. I think there is the need to sort of try to interpret this not only as an economic objective, but also in a way, Kai said moral judgment, refer to a moral judgment. I wouldn't go that far, but definitely it's something, it's an interplay between different kind of objectives and considerations to be done. So it is, to sum up, the DMA definitely sets the grounds for these kind of conversations. What we're trying to stimulate is this conversation to be a little bit more imaginative, more ambitious in a way, especially now that it's still the time where this proposal is discussed by so many different stakeholders with so many different views, etc. So it can be very enlightening. On the other side, I think the second point I'd like to raise here is what could be improved in the DMA. Highlight points, not to take too much time to the other speakers and then the discussion afterwards. I need to echo again what has been said, so a little bit more, definitely more focus on the end user's perspective, from both from a substantial point of view and from a procedural point of view. I think for a procedural point of view, from that point of view, I would also mention Article 10. I do think that we need an amendment in Article 10 in the second paragraph, because I do believe that it's important for the Commission to consider in the future the possibility of having new behaviors that are unfair, and to qualify this unfairness based on the balance of rights and rights and obligations in between the core platform and the end users directly, and not only the core platforms and the business users. So this might be something to consider as well. Finally, we do have, if we read Article 5 and Article 6, we do have a number of provisions that are directly trying to open up the market to rivals. Yet, some of those provisions, they do, for example, address issues of tying or bundling. One of them is the pre-installation, uninstallation provision. So some use cases, let's say, are addressed. There are many more that are missing, and it would be a good idea to try to address them already in the proposal, not only through the possibility to impose further obligation. I just conclude with raising one of those possible use cases where maybe we can think about a specific provision, which is, I refer again to the social media markets. And currently in social media markets, there is one instrument that we think social media are using to raise barrier to entry for potential third parties, which is the bundle, offering the hosting and the content creation activities as a bundle. So this specific practice, we think it is an impediment to contestability, and it also creates a lot of problems for end users. So maybe one of the possible addition in the DMA could be to oblige platforms to unbundle those two services and to provide access to third parties for get in and provide their services, their content creation services on the market. I'll stop here and I thank you again.
Thank you very much, Maria Luisa. You have raised points that later on we will discuss. And don't worry, those who has already given your talk, you will have the opportunity to react to issues from others. Before passing the floor to Ian, just to remind you all, the ones who are attending, that you can send your questions in the chat. We have received some questions in advance, but feel free and do not be shy on sending questions. We have a very good panel here of experts, so it's a perfect opportunity to hear from them on issues that you are interested in. So, Ian, the floor is yours.
Thank you. Thanks for the opportunity to speak to you all. I will be brief so that we can maximise our time for discussion, and I agree with much of what has already been said. Very briefly, I have been researching as an academic interoperability as a mechanism to improve digital competition. Since 2008, I wrote quite extensively about it in a book I published in 2013 called Regulating Code. And I think it's really interesting as not just an economic competition measure, and we know from the various digital competition reviews that have taken place over several years now for Commissioner Vestager by the Competition and Markets Authority in the UK, equivalents in the US, in Australia, in a number of other jurisdictions, many of which have concluded interoperability mandates for the largest platforms, the gatekeepers in DMA terms, could be effective in improving contestability for services, particularly like social media and instant messaging. But I think it's also very interesting from a societal perspective. So the focus of today is on end users, and I think end users individually, but also collectively as members of society, have a lot to gain from greater competition in digital platform markets. And let me give you just some examples. Isa already mentioned a couple of these. I think several speakers, I think including Inge, have said platforms have become really critical communications infrastructure for our societies, particularly during the pandemic. I know friends of mine who are parents, their schools frequently now use WhatsApp or Facebook groups to communicate with the parents of classes. Of course, that creates issues if you as a parent don't want to use services from that particular company because of its well-known issues with its privacy policies. And I should say I deleted my Facebook account years ago, but have still not felt able, just to give you a personal example, to do the same for WhatsApp, because so many of my family members and friends are only reachable via WhatsApp, particularly in WhatsApp groups. I would like to be able to use Signal or other more privacy-focused messaging tools to communicate with those people. We see interoperability can give great incentives to offer better privacy. So to give you two examples, DuckDuckGo and ProtonMail are two great small tech companies providing privacy-focused email and search. I think we would see a lot more use of those kind of platforms and a lot more incentive to develop those kind of services if they were able to take advantage of interoperability requirements on gatekeepers. And indeed, the Commission's DMA proposal already includes a specific requirement on search engine gatekeepers in Article 6.1J. I'll come back to how I think the proposal could be strengthened in a couple of moments. I think I have a long list of potential societal benefits, but I'm not going to go right through them. Very briefly, I think it could also contribute towards the EU's environmental goals, reducing the throwaway economy that we see in areas like the Internet of Things. I think it could strongly favour Europe's digital sovereignty. I think the ability of European companies to enter some of these digital platform markets that have now very heavily tipped towards monopoly in a way that actually will be very difficult to bring back to competition without the kind of strong measures that are envisaged in the DMA, and perhaps strengthening the DMA even further. And finally, just to pick up on what Isa was saying at the end, no one forgets, of course, the twin, as Inge, I think, called it, of the DMA, the Digital Services Act, and actually the DSA Article 29 has a very specific measure already relating to curation and recommendation algorithms that platforms use with users' timelines. And I think actually inserting an interoperability mandate there too could really do a lot of good in other policy areas that the EU is very, very focused on. So for example, moderation of harmful content. Why not give users the choice to pick recommender systems from third-party providers that meet their own values and needs and judgment, and that way promote diversity in moderation algorithms, promote media pluralism and diversity more broadly. So I think the DMA and this part of the DSA could do some really interesting things for social policy in the EU as well as economic competition policy. I wonder if you could put my table up just for one moment, because I do have very specific proposals for people who are interested in amendment text to the existing DMA proposal, and I'm very happy for BEREC to share this with anyone who is interested in participating in this meeting. So the first three amendment proposals you can see at the top there. This is picking up on a point that's been made by several speakers already, making sure the DMA gives specific rights and protections to end users and not just business users. So even Kay was saying the DMA should not be focused on business rivals of platforms, and I think this would be one way to do that. I'm not going to go through the amendment text, but you can see particularly in Article 3 of the DMA proposal, there are some areas I think it would be explicitly worth adding end users as well as business users. Then if you could please scroll down. And then I think the really critical way for me, the single way that the DMA proposal from the Commission could be strengthened and do more for end users and for these social policies as well as competition policy that I mentioned, would be amending 6.1f, which Vanessa already specifically mentioned, to say that interoperability mandates for gatekeepers should not be there just for ancillary services. Actually, it should cover the core services as well. I think we have a lot of evidence from the reviews I mentioned earlier now that in particular, social media and instant messaging services, we could greatly improve competition in those markets by requiring interoperability. From a technical perspective, I think we'll come back to this in the Q&A because I know a lot of issues are raised about on the technical side of this. I am actually a computer scientist. I was a professor of computer science at Oxford University. I've done a lot of work on interoperability over the years and how you would write these kind of tools, including, for example, end-to-end encrypted instant messaging tools. And I do think that the technical issues can be dealt with. And indeed, BEREC has a lot of experience with dealing with similarly complex technical issues that have come up in these kind of interconnection and interoperability requirements in the European Electronic Communications Code. And then just the last point there, Article 10.2, reinforcing the point again that the Commission should be taking into account explicitly the need of end users as well as business users. I think that those are the key points that I wanted to make at this point, and very happy to come back to specifics in the Q&A. The final thing I would say is really to echo particularly what Vanessa said. I think if the DMA was heavily amended to become an effects-based ex-post instrument, I think we might as well give up and go home now and just stick with 101 and 102. I really do think that would be an enormous waste of everyone's time. Thanks.
Thank you very much, Ian. Yes, later on we can discuss technical issues on interoperability, because interoperability is a topic that is raising many issues and discussion, and we even have a first real-time question. So take the example and raise more questions. And now it's time for the Electronic Frontier Foundation. So I think that let's go directly. The floor is yours, Christoph.
Yeah, thank you very much. Hi, everyone. I very much appreciate to be invited to this great exchange. Let me just let me explain who the Electronic Frontier Foundation is. We are a non-profit organization, and EFF defends freedom of speech, privacy, and innovation online. So what we do is to have user rights and the free internet at heart, and we consider the initiatives for the Digital Services Act and that for the Digital Markets Act as real opportunities to address some of the most urgent problems that we can spot in today's internet. And we think that many of these problems that we can spot relate to the problems of bigness, so that platforms seem to have monopolized a great deal of the internet, and they've built entire ecosystems. And quite often they did that not via innovation, but through acquisition, as we know. And like Maria Luisa put it, those ecosystems are at the same time huge communication spaces. This has huge consequences for user rights and freedom of speech. In a lack of contestability of the market is bad for innovation, of course, but there are all the associated consequences end users feel when they are not really in charge of their online experience. So we see that users face misleading architectural design choices, polarization of debates, amplification of problematic content, and we also see discrimination of marginalized groups. So what we would like to do is to change this equation, and perhaps by reflecting on how an open internet could look like, and to make suggestions to transfer some of the power that the platforms currently hold back to the users. We believe that it should be up to users to understand how algorithms work. They should have options to control the destiny over their data. They should have better options in case that they're unhappy with the platform service. And we believe that the Digital Markets Act can play an important role here. Like the Commission has put it, it's the idea that platforms should behave in a fairer way online. We believe there's a lot of good stuff in the proposal, actually. We like the self-executing design. We like that it comes with effective penalties to ensure compliance, or even structural remedies for platforms that won't stop engaging in monopolistic behavior. And some of the banned practices, and I will not go into detail, they're very good suggestions. We like the ban on mixing data. We like the ban on forced single sign-ons. We like the ban on cross-tying of data services. And we like the ban on logins. All those measures can really help to ensure fairness in digital markets, and we can only urge the Commission to keep those things in during the negotiations. However, like other fellow panelists have already pointed out, we believe that the DMA proposal could do a bit more, and especially put a stronger focus on the perspective of end users. And I think that we also need to have a discussion about the role of civil society groups in all of this. And like others, we do believe that an interoperability mandate would be really the right lever to actually affect that behavioral change the Commission hopes to achieve with the DMA. And I would just like to say a few words about interop. We will have a discussion later, and many panelists have already mentioned why it could be useful. For us, it comes from the observance that platforms have the unilateral authority to decide who gets to use the service. And due to the strong network effects, it seems that operators of those platforms are not concerned at all that users switch, for example, if they face a lack of privacy or if they're unhappy with the content moderation policies. Like Ian put it, like he wouldn't leave WhatsApp because he wouldn't want to leave the friends and family members behind. So what happens in reality is that users must choose between a social relationship and privacy, or a social relationship and harmful content. We believe then that in a competitive and interoperable internet, such a dilemma would not exist. Users would simply choose a service that better protects their interests, whilst they could still stay in touch with their friends who don't switch. And as a result, the incumbent platform would be incentivized to treat existing users better. So for us, interoperability can smash not only their monopoly power, but also give users more agency over their data. And this is why we as well think that the DMA and the DSA are a tandem instrument. Both foresee asymmetric duties, both have this options to give users more control over their online experience, informational self-determination. And we believe that both the DSA and the DMA, they are good instruments, but both should be improved. And I think that's all from me for the moment, and I look forward to the discussion.
Thank you very much, Christoph. And this is the last speaker, and then we enter into the questions, and it's from one digital platform that we all have used and are using. I would say that it's a gatekeeper of knowledge. Perhaps gatekeeper in this context is not the right tool, because the idea is not to apply regulation, but it's very interesting and fresh to see the views from the Wikimedia Foundation. So, Anna, the floor is yours.
Thank you, Jorge. Also, thank you for bringing this perspective of whether Wikipedia or Wikimedia is or isn't a gatekeeper. I would love to. No, thank you, because it's a very interesting case, and I hope we can discuss it in the roundtable when we talk more about interoperability and risks and how to do it and how we experience this. I am in this either not very comfortable or very comfortable situation that I am the last, and I agree with many of the speakers, I must say, sadly, except from Kay, on the points that were made. And I also hope we can discuss this more, where the disagreements come from. But nevertheless, let me first of all explain why are we, to add to Jorge's explanation, why are we even at this table. So just to make sure Wikimedia and its various institutional nodes, and especially Wikimedia Foundations, the Wikimedia Foundation is the organization that makes sure that there are servers running to keep projects such as Wikipedia. We are more of a custodian of that space from the perspective of the technology and indeed the keeping it online. However, we have a community of users who are also a governing force in projects such as Wikipedia. So this is really a different model of envisioning what is the role of the platform itself. So of course we are very interested in all the perspectives that affect the users of our services, that are of course also the contributors, the editors, and also the curators of the content that is there. Of course, on the other hand, we are a platform, and from legally speaking and looking at liabilities, we are very interested in looking into the laws and frameworks and ideas that may shape that part of our reality. And finally, we have also a care and concern about the internet as a whole, not only about our project. So, because we also rely on the health of the internet, if you may say so, we rely on information being able to circulate freely and on people being able to access it and to produce it. So this is how we approach this regulation, and DMA is of course interesting to us from some aspects more than the others. Let me quickly give you a kind of short perspective on how we look at it, also making a connection to what my great colleagues said before for clarity here. So when we talk about caring about the shape and the of internet and the way it works, we clearly see in our movement that we are now in this phase of development of our online experience, where not only we experience a lot of network effects and the tipping markets are our reality as well, but also it's the moment of everything being actually intermediated. If we look at this, a lot of what we do online and most of the things we do online are now going through the internal and very secret sometimes mechanics of very few actors actually, and this is something that has to be reckoned with. So when we look at how to regulate this ecosystem that is intermediated in such a extreme way, we have to look about who those gatekeepers are and what they do and why they are who they are. This is how I would phrase it, and this is where the DMA provides some explanations and some perspectives on this, and doesn't provide some of them, and maybe we can do something about it, especially with regard to the users. So if we look at who those gatekeepers are, when we look at the definitions, we are first of all happy that there is an attempt being made to actually differentiate those big actors in a way that matters legally, because so far what we've seen in different other proposals were definitions that try to engage with understanding what is passive, what is active, and this is not satisfactory. This is very difficult to in practice to say, and for the purpose of this regulation, but also for the purpose of understanding the differences between the different actors online, making a difference the way that it is outlined in Digital Markets Act is a step in a good direction. As Mr. Schwab remarked before, we can discuss whether the qualitative or quantitative benchmarks are more effective or appropriate, but there is a merit in trying to look at this. We wished that there is more consideration in the definition for looking into the business model based on data extraction and basically profiting from surveillance, but perhaps this is not something that could be tackled in Digital Markets Act as it is now designed, and maybe we should also think about it as a kind of multi-componental change in European legislation that employs also other solutions where those ideas could be further developed. As to what the platforms do, definitely we see that the part of the harmonizing the digital single market is much better addressed than the competition aspect if it comes to end users. Last month, Commissioner Breton said quite openly in the Code Committee that this is not a competition instrument, that DMA is the instrument of the digital single market, and I think it comes with its own limitations. So again, without repeating many great points that Christoph and Vanessa had made, and Isa as well, there are some solutions that are provided that should be further worked on, especially interoperability. I completely agree with Ian that that this is something that should be addressed, and thank you for those ideas. I would be happy to look into those proposals in more detail. But at this point, when we only see the Commission's proposal and no other version of it, we can actually, I think, agree that the users are a bit of an afterthought in this regulation. Then finally, when we look at the aspect of why those gatekeepers are who they are and what can we do about this, I think this is where the Digital Markets Act is the weakest, in the sense that in the way it's constructed, in the way it is presenting the proposals that are both self-executing and those that then will be delegated further into the deliberations between the Commission and the platforms, and hopefully, as Vanessa says, and proposes also other actors in this ecosystem. This is basically to us at Wikimedia, the Commission saying, well, this is where we are. We have those gatekeepers, they are here, we can rein them in, but there is not much to do as far as Digital Markets Act is concerned to actually change the balance of power on the market. And this is where the instrument that would be more focused on the competition and more focused on users would, I think, go a bit further. So of course, it's hard to speculate because we don't know what will be the final outcome of the deliberations between the European Union institutions. But if you look at the Commission's proposal, in the best case scenario, to me, we may have better gatekeepers when it comes into act, but we will still have them and not much else will change. And this is where both looking into the empowerment of users could actually help, and also, again, in other instruments that could be brought into this whole legislatory framework that could help DMA be better and serves the users better. So this is from me, and I'm happy to discuss further, and I hope we can disagree a little as well, and come out from this debate even more, even smarter. Thank you.
Thank you very much, Anna, for being the last one and taking the complex position of being the last one. You have raised many additional interesting issues. And thank you to all for being on time and leaving us. We have now 3/4 of an hour for open discussion, the questions, and you have seen we have several questions. But before starting with the questions, if any of you would like to react to anything on what you have heard from others, for example, on interoperability, we have questions also on interoperability, but feel free to do so, and it's a good way to start. Anyone would like to break the ice reacting to anything said by others? Then we, okay, yes, please.
Yeah, sure. I'll start off and let everyone else react to all my terrible points. That's no problem. I mean, I should be very clear for Professor Brown. I wasn't talking about ex post the same, so it's not fair to recharacterize that as something else. But it's all explained in CCIA's position paper. But on the topic of interoperability, since I know that's of great interest to everybody, I'll dive into it and say, interoperability can be very good. In the Microsoft case, CCIA complained and intervened in the US and EU processes because of Microsoft's unjustified removal of pre-existing interoperability and its unjustified discrimination against competitors. So we definitely think that when that kind of stuff is done in an unjustified way, it should be prohibited. The question is, where do you draw the line? And that's why we say you need to be able to understand the effects. Now, that can come in on the justification side, as a lot of the expert reports of the last years have said, that you would then give the company the opportunity to defend itself. That would address information asymmetries, and it would force the companies to come forward with more information to substantiate the interests, the consumer interests, and the benefits of the conduct that is to be prohibited. So to clarify. But speaking of interoperability specifically, it's very tricky and raises a lot of questions. Now, I'm going to tease Ian again and say users shouldn't need to be a professor of computer science to use the devices and services that are so popular today. Recent cross-country consumer survey by Professor Pinar Ackman shows there's a lack of digital literacy. A troubling number of people can't distinguish between a browser and a search engine. So we need to be careful not to overcomplicate things when a lot of the growth of the technology sector is because of devices and services that just work seamlessly. So then there's a lot of other questions as well. Interoperability is a form of standardization. It's about speaking the same language. So the question is, whose dictionary do we use? Do we want to use the Facebook dictionary or the Google dictionary? If not, we need to have some other body to oversee the standardization process. The DMA right now does not foresee any kind of participative dialogue on this standardization or the need to provide any guidance or explanation of what the standardization would look like. Requiring interoperability where none previously existed is also a big task. It requires a lot of investment in engineering. It can mean a lot of, it could take time and technical development to come up with what is this dictionary going to look like. And it can mean dealing with companies that you wouldn't want to otherwise deal with. So we need to balance out that we're right by imposing interoperability where none has existed, a de novo, first of its kind interoperability obligation. We're telling companies that they don't have the choice of who they want to contract with, and we're taking away some part of their freedom of conducting their business. This can be justified. It's justified under competition law as well, but there's a relatively high barrier. How do you justify it when you're not looking at the effects and the repercussions? And to allow governments to impose this without looking at these effects, it's quite revolutionary. As BEREC has pointed out, requiring interoperability changes some incentives for the gatekeepers. You have to look at what, courts and competition enforcers have long understood this, and expert economists, including those of the Commission, universally recognize that companies cannot appropriate the value of their investments, they won't make them. Now, I'm not saying, again, that this is a question of appropriation, but we have to consider these kind of things, especially when these kind of provisions might then be imposed on companies without market power that don't have the incentive or ability to engage in extractive behavior. Interoperability also changes incentives for rivals. Now, this is the really important one. Instead of coming up with a competing service like TikTok or Hopin, European rivals might choose instead a remedy taker business model or an access seeker business model. This isn't going to encourage the kind of autonomous rivalry that digital sovereignty is supposed to be about. Instead, all these rivals, European rivals, would be dependent on that infrastructure service that is being provided. And we know in the telecom sector, when these access remedies were imposed, that these are not easy questions. These are not like one and done. It takes a long time to solve this kind of problem. And I mean, the last thing is just because the example was used of being able to message people on WhatsApp using another service, there's also a security and privacy concern. I mean, it sounds nice, but do we want to open up all these platforms to less secure players and sources from Russia or China or wherever? That's something to consider as well.
Thank you very much, Kay. Anyone wanted to react, or even to react to Kay? I don't know, Ryan, because we have also pending the issues technically.
I've raised my hand.
Yeah. Yes. Right. I see it now.
I'm being polite. Jay, interoperability would change incentives. I hope so. I don't think the incentives that we have for the gatekeepers today are particularly good ones for European societies or other societies. It may change them for small players. Of course, the DMA obligations apply only to gatekeepers, not to small players, and it would be entirely up to small players if they wanted to take advantage of interoperability mandates on gatekeepers. And in turn, it would be entirely up to their users if they wished to connect to people via interoperability on gatekeeper platforms. And actually, that's an important part of the answer to FUD, I'm afraid, fear, uncertainty, and doubt from companies like Facebook on the impact on security and privacy. I'm sorry, I hope this doesn't sound smug or boastful. I was Professor of Information Security and Privacy in Oxford University. I've been working on those topics for 20 years. I promise you I am not here trying to encourage you to policymakers to change things that will damage privacy and security. I think the spread of end-to-end encryption, including via platforms such as WhatsApp, is in general a very positive thing for society. And as I've explained to more than one MEP in the last few weeks, interoperability requirements do not break end-to-end encryption. You have the devices and the software at both ends speaking the same language, as Jay put it, and able to encrypt messages in a way that can be delivered directly to their recipient without an intermediary, whether it's the gatekeeper or somebody else breaking that encryption. That brings me on to the dictionary question that Jay raised. Indeed, to make interoperability work effectively, you need processes by which either the industry itself, I mean, at the lowest level, the gatekeeper, at a slightly more interventionist measure, an industry body, including competitors. Going further, a technical standards body. The EU uses technical standards in all sorts of areas of single market regulation. Obviously, it's a really important way to stop non-tariff barriers being put up by member states and by others. There are European specific standards bodies. ETSI is the best known one that writes a lot of telecommunication standards. There are global standards bodies like ISO. There are global, more private sector focused standards bodies like the Internet Engineering Task Force and the World Wide Web Consortium. Actually, one thing I would particularly specifically disagree with Kay on is the idea that instant messaging and social media interoperability would require whole new layers of standards, that this would somehow be novel. That's completely wrong. The IETF and W3C have got very well developed technical standards for instant messaging and social media. In fact, Mastodon, which I'm sure some of you will have used, which has over 4 million users around the world, is based on the W3C's ActivityPub open standard. Facebook itself used some of the IETF's interoperable instant messaging standards before it closed off interoperability with its services in the last decade as it became more of a dominant player. To be particular, Jay, on your point about ex post, what I particularly want to avoid, and I think would be very damaging and would make the DMA a pointless exercise, as I said, is to see obligations coming out of the DMA being endlessly reviewed, challenged by some of the world's historically most wealthy companies, and 10 years later, the Court of Justice saying, okay, this is justified, or okay, this is not justified. As I said, we really might as well give up if we're going to move towards that kind of model. The DMA is not done on the basis of the competition competence in the treaties. It's done on the basis of the internal market competence. So I think from a legal perspective, we should avoid that route at all costs also.
Thank you very much, Ian. Anyone wanting to additional react? If not, we have here very interesting questions. Let's go through the questions and move to another topic. A very interesting topic raised by Christina Barbov. I think that is coming from the UK front Ofcom. Is that she's interested in knowing your views on the idea of separating the aims of contestability and fairness in the DMA to treat them as separate aims in their own account, something that may assist in enforcement of Article 5 and 6. So, some way, do you see a case on separating both? Any ideas on that? views on if they could be separated.
Maria Luisa wants to intervene.
Maria Luisa.
Yes, thank you. I think if I can, I just take the first 30 seconds to add on what has been said about interoperability, because I raised my hand also silently before. And then I'll take this with pleasure, this question, and I'll try to provide a couple of suggestions. So on the interoperability, what I think is also interesting is that it's pretty diffuse, this narrative, that sometimes we need to try to, yes, not to make things too complicated for users, or that we need to protect them. But the truth might be that we could look at these things from a completely different perspective. So a good way to protect users could be to empower them, and a good way to empower users is to give them information and choices. And I don't think that this is alternative to interoperability. I think they go actually in the same direction. So I don't think that end users necessarily by default, they will feel more protected if they're into an ecosystem that is completely closed and controlled by one company, rather than if they feel empowered to pick whatever they think is best, and also to pick eventually risks. But at least they should be informed about this and be able to make their own choices. So together with the excellent technical points that have been raised, I think it's also a matter of narrative and perspective sometimes that we need to take into account. On contestability and fairness, I think, let me put it this way. I do believe that Article 5 and Article 6, the obligations in Article 5 and Article 6 could be better categorized and could be grouped into yes, different groups, depending on the specific objectives they have in mind. And maybe this goes in the direction of having contestability and fairness as possibly separated. Another possibility could be, and I think BEREC has mentioned this in their own response to the DMA, is to have ex-ante principles that could help interpret the different provisions. So I think what I'm trying to say is that I do perceive that there is certain uncertainty and unclarity on how to interpret the different provisions, and which one should, are addressing a specific goal, and which one are directed to the other specific goals, so contestability and fairness. And I think more clarity, and possibly, as I said, ex-ante principles or principles that should be used to interpret those could definitely be of use. Not to say, I'm not saying that we need to keep those two completely separated. There will be overlaps, there will be synergies, they will need to work together, etc., etc. But yes, I think it would be helpful to understand, especially for the gatekeepers themselves, to understand if that specific obligation is more directed to contestability for goals or fairness goals. Yes, that would be my approach.
Thank you very much, Maria Luisa. Chiara, go. Yes,
yeah,
see.
Maybe we'll go to the next question if there is nobody else who wants to intervene on this one, because it's quite, I can make the link with what Maria Luisa has just said about the tailoring, let's say, in case by case of some obligations and remedies. And it's so we received a couple of questions about this, and it's also one of the remarks that I wanted to do during the presentations which were made before. And it is about, so in our opinion, we say that this regulation must be future-proof. So instead of being only based on these known and past behaviors, the European Commission should also have the mandate to design and adjust the remedies. But this is on top of the this self-executing obligation. So we have a couple of questions on this. The first one is coming from Bird and Bird, saying, do you think that the DMA with its self-executing remedies strikes the right balance between regulatory certainty and flexibility to tackle the new developments? And the second one from Telefonica, it's about how to explain a bit more the self-execution approach, because one thing is avoiding an endless efficiency defense with which Telefonica agrees, and another thing is making sure that the remedy is working from a technological point of view, because otherwise it will be useless for business users and end users. And just to clarify a point in the position of BEREC, when we talk about case-by-case basis, so it is very different from competition law. because sometimes it can be interpreted like that we ask for a case-by-case competition decisions, but actually it's rather like what we do in ex ante regulation, the case by case. So it's a definition of the remedies which is happening ex ante based on some principles that you have in the law. This can help also to tackle new issues. So there will be like some ex ante clear principles in the law, and then it would be up to the regulator to define and see, for example, what an essential input is today, but maybe it's not the same thing in 5 years, and so on. So it would be this kind of flexibility, but not case by case on ex post behavior. So it would be rather like identifying the structural problems and define remedies around this. So this is just a clarification from the position of BEREC. So I'll let you react on this self-executing remedies, so certainty versus flexibility, and then the question by Telefonica that says, okay, the tailoring of remedies is actually also needed from a technological point of view to make sure that these remedies actually work. So I don't know, Vanessa, if you want to, yeah, please.
Yes, thank you. I'm very happy to come in on the Telefonica question. I would agree with you that we need to make sure that in the self-execution that from the technological point of view that the solution works, and as a result of that need, that's where we think it's very important that in any discussion under Article 7 of the implementation of the obligations under Article 6, that it's not just the gatekeeper that is involved in those discussions with the European Commission as the regulator. We think it's absolutely essential at that point that the beneficiaries, be they consumers or business users or both, or if we're talking about interoperability, then other competing service providers are involved in this, because if they are not, there is a real danger that the remedies won't work. Unfortunately, we've seen that arising in competition law cases. One only needs to look at a couple of the cases in the search world, or the comparison shopping world, that not involving parties who are going to be directly affected can lead to an outcome that doesn't actually achieve what the remedy was designed to achieve. And that's something I think we definitely need to avoid in the DMA, and therefore where there is a need for interpretation, it should involve all those parties concerned. Now, I know that may lead to a small delay, but that's not the kind of delay that is going to be material, and getting the answer right is going to be far more important than adding a few more weeks on as a result of discussing with other parties. And perhaps just while I'm speaking on the subject of delay, the effects-based approach, I think we know what the main effect of that effects-based approach would be, and that would be delay. For many of the conducts, we know exactly what the effect on consumers is, and we can take one example, the Google search cases, which have looked at the issues that are now in part covered by the articles in the DMA. Those cases, the Commission's competition cases in relation to Google search, the Google shopping case and the Google Android case, both which relate to the types of conduct we're looking at here, have gone on in the case of the shopping case for more than 10 years. And in the case of the Android case, for more than 6 years. What is the result in terms of the market for search engines? Well, if we look at StatCounter's market share, Google has had more than 90% of the market for the last 12 years. So I think that clearly shows you the effects on consumers of the type of conduct and the situations that we're looking at here. So I'll stop there and let others maybe come in on the other aspects of the self-executing provisions.
Thanks a lot, Vanessa. Kay, please.
Yeah, I mean, I again, just so I'm not taken out of context or misunderstood. Clearly, if something is well known to be harmful, then you would imagine it would be very difficult for any company to prove any justification or positive effects from any conduct. So I don't think it, where there is a clear evidentiary record of conduct being harmful, then I find how easy is it going to be to prove positive effects? I don't think that is going to really delay things. But I think we agree that consumer interests should be considered. So how do you do that? There's going to have to be submissions where the consumers talk. You get an impact of what is this going to have impact, the effect on consumers, and you look at that. If you're not looking at what the effects of the intervention is, how can you get it right? That's one of the main issues of the Google shopping case. We're involved in the appeal. Full disclosure, we're in court on this issue, and we say the Commission didn't look at it carefully enough, and all the effects and the impact and the broader repercussions, and that's part of why they got the remedy wrong and why people are very unhappy with it. But also to note that if we take a snapshot of that market of shopping comparison services, things change. So these days people do a lot of their comparison shopping on Amazon, where they can purchase directly instead of going through the advertising of a comparison shopping service. The market shifts. So if we set in stone what the market should look like based on these competition cases, which you say are from 10 years ago, today, and say that's how it's going to be forevermore, how is that going to make Europe a more competitive digital economy?
Thanks a lot, Kate. Maybe we go on with the other questions because we are receiving.
Yes, and let's switch to another topic related with some of the questions we have received. That it's about the consumer behavior and what can be done to improve issues. Is that, as you know, end users are sometimes said to make ill-informed choice, essentially because they are not fully aware of the consequences or the digital behavior, for example, giving consent, sharing data, etc. First of all, do you agree on that? And if so, what do you think that can be improved? In this line, we have a question from Eliane Mal from DuckDuckGo. That is that if you think that the DMA should empower end users for choosing their default search engine on their device, and not only he refers not only to the default search engine, but also to the possibility to extend to other core platform services. So, what is your view? I mean, do you think that the DMA should impose obligations in that line? So, anyone wanting to take the question first?
There's Ian and Christoph. Jorge.
Yes. So, for example, Christoph.
And Vanessa has raised her hand too. I just saw it. I think I don't like to the phrasing or the narrative of ill-informed choices. I think what we see is that there are no actual choices being made, and the question is, why is that? And there are many reasons for that, why we don't see actual consumer choice. It could be because of nudging, of lack of transparency, of behavioral design choices, and many other practices. But this doesn't mean that an actual choice and consent cannot be achieved. It just needs to use regulation that focus on transparency, on dark patterns, or to put the burden to achieve consent on the shoulders of companies. And that brings me to the question in the chat that could be done by privacy by default mechanisms. I mean, there's a very long way from information to awareness to knowledge and wisdom, but modern rules can benefit a lot from behavioral insights, legal design, and protection by default. And I think that privacy by design and choice by design is a good idea. Like if user data are not processed by default, it's up to the company to ensure true consent. And the same holds true for search engines. It should be up to the users to decide what is the default engine. It should be then up to the companies to make an informed choice possible. So I think that's something we should look into, how to actually enable user choice rather than starting from the assumption that consumers make ill-informed choices because of some deficits in their decision making. And I hope other panelists can elaborate a bit more to explain the consumer impact if in case that we decide we would like to see this covered by the DMA, because the consequences would be tremendous.
Thank you very much. Ayan or Vanessa? Ayan, perhaps.
Okay. Briefly, I think it's not an area I've focused on, but this is perhaps one of the biggest gaps in the DMA proposal to me. Looking at the UK Competition and Markets Authority excellent report from, I think it's July 2019 now, where they went into an enormous amount of depth, used their powers to compel the production of all kinds of data from the industry, did a lot of analysis themselves. The key thing that they proposed in relation to search, to making search contestable again, was actually this kind of what they called fairness by design. As Christoph said, it should be an obligation on companies, on gatekeepers, to enable their users to make fair choices, not to say, tough luck consumers, you know, as we see at the moment. I follow Aurelian on Twitter, and I just saw him tweeting earlier how many steps it takes to change the default search engine on Android, and how infrequently users ever get that choice, actually. So I think that's a good example of how not to do things. And I think the DMA putting a duty on gatekeepers to actually, whether you call it fairness by design like the CMA did, whether you use more traditional competition language like avoiding self-preferencing, for example, in suggesting neighboring services from a gatekeeper. I think this is really important, and it's been a big problem. I think we can learn a lot from the GDPR with the DMA and the DSA, and this is one area where, as Christoph said, the GDPR actually has a good provision, Article 25, on data protection by design and default. The problem is, much like the rest of the GDPR, it's just not enforced by and large, and I've not been focusing on the enforcement provisions in the DMA. I know my co-panelists have, and the GDPR is a wonderful lesson on how not to do things. I think that there's a lot of many positive things to be said from BEREC's point that national regulators should be able to lend their expertise, but as BEREC has said, you still want it to be centrally organised and focused by the Commission, because if you don't do that, one of the big problems the GDPR shows is you just get a race to the bottom of the location of the weakest regulator in the 27 member states, becoming an enormous competitive advantage for that member state. I mean, to the point with the GDPR, never mind the Commission taking infringement procedures, I really think it's becoming a threat to the single market, and they should be using some of the other stronger treaty provisions on that.
Thank you. We have Vanessa and then Anna. Vanessa?
Just very briefly, I agree with what the previous speakers have said completely, and would say I think this issue of defaults and generally how you present information to consumers can very strongly influence how they react. One of the things that we think in terms of defaults is that it would be very important for the DMA to include in its Article 6.1c not only the right to install new apps, but also to set them as defaults, both for the end user and potentially for business users, and also that the gatekeeper be obliged to prompt the user as to whether he wants to set or she wants to set their newly downloaded app as a default. So there are a number of really important points that should be strengthened there to give to consumers genuine choice. And as the others have said, and I won't spend too much time on it because I've mentioned it before, it is very important how you present information to consumers, and platforms don't have an incentive to make sure via information or their design interface that consumers can make informed choices, because most likely those choices will not necessarily be in the interest of the platform. Therefore, it's very important that we have neutral choice ability for consumers, and that the DMA specifically calls this out in the anti-circumvention provision, as I mentioned earlier. If we really want this to work, then you have to present information to consumers in a way that they can use it. It's not the quantity of the information, it's the way that it's presented that will give consumers the ability to make informed choices.
you very much. So now, Chiara, do we move to the question on ecosystems?
We still have two speakers, and Maria Luisa and Anna.
I never see small hands. Yes, Maria Luisa, please.
Thank you. Well, now it's difficult to find something else to add, but I have to say maybe two small points. The first one is that this idea of what has been discussed, the faults, etc. I think is one of the niche arguments where we see that the DSA and the DMA discussion should go together. There are a number of provisions in the DSA that focus on very similar points, so it would be a true pity and a real problem to have conflicting positions in those two instruments. The second point is another way to help end users, I think, to make informed choices, to give them more information about how the core platform services function. And an essential component of that is about the transparency and the audit provision. I'd like to point for a sec at Article 13 in the DMA. So Article 13, as we're familiar with, it imposes this audit obligation on gatekeepers, and it goes on as to cover the profiling. It stops there though. So my worry is in a number of use cases, a number of core platform services, the trend is not only to profile users, but also to personalize the service, being this the content they see, or being this the search queries they access to, and so on and so forth. So perhaps a very good point in informing end users and creating more transparency would be to also expand the scope of this auditing as to cover the actions that are performed, especially when we're talking about automated system, by the different platforms in the personalization of content, so that users know why they see what they see, or why they access to what they access, and they don't only know that a number of data among them are collected in order to create a profile. That it informs them this personalization choice. So yeah, those were the two minor additions I wanted to make to this discussion.
Thank you very much. I think that we have Anna and Ian. Did you wanted to react again or no? So Anna.
Just very quickly, because similarly as Isa said, a lot already has been said. I wanted to build on Christoph's point on choice, that sometimes it's very much underlined that, you know, the more choice you have or the more control you want, the more complicated it is for us as end users to take those decisions. I think that it's not entirely sort of by default like this. I think a lot of that depends on how we present those choices and make them actually accessible for users. And Kay mentioned the innovation coming from the big actors and their experiences in creating good users experience and seamless interface / user interactions. And I think that what interoperability could actually offer is to redirect some of this attention of those brilliant people who now work on attention capture and on keeping people locked in the certain ecosystems, to make those choices as seamless and as easy as possible. I think we never look at it, or hardly look at it from this point, that there may be an effort and also an opening of a new way to compete, is to actually make sure that if interoperability is necessary and it's actually working, then the more interoperable your services are, the more people are attracted to what you have to offer, because they can access it from so many points, and those points of access are easy to understand and easy to see what is the benefit of using this provider and not the other. So so just to remark on that. Thank you.
Okay, I see Kay wants to intervene. Is it on the same question? Because we still have a couple. Yes, okay, please.
Sure.
Yes. We can't hear you, Kay.
we've seen through the history of innovation that sometimes incumbents are not the best place to create those new models and technologies. And I just want to flag for everyone, I'm sure some of the people on this already know, but there is already this new Internet 3.0, new technologies, a new technological infrastructure that is out there, that is decentralized, that has no gatekeepers, that is based on interoperability and standardization, that is growing rapidly, very popular, and that is out in the market. So that other solution is growing and is becoming real. While instead of trying to encourage that, the DMA sorts of looks at things from 10 years ago and says, oh, actually, why haven't comparison shopping services been more successful? Let's make sure that users are forced to go and visit them. You know, force them to be put higher in the ranking, this kind of stuff. We need to, like, sometimes competition can work. I would say in many ways it is working. If you look closely at the frontiers of innovation right now. And so we just to make sure that the DMA doesn't inadvertently reduce competition and dynamic innovation in the market.
Thanks, Kay. So as I said, we still have a couple of questions and only 10 minutes left. So I will try to condense the questions I had on interoperability, but I would really like to ask them because I think it's one of the key points of these proposals, or how to make these proposals better. And so I have, let's say, some questions which we can resume. So the first one is about how to make it work in practice. So how does it work actually in practice? And another one is more about privacy and security. And so it was a bit touched upon already by Ian and Kay before, but maybe just to structure it a bit. So the first one is how does it work in practice? So does it mean that there would be the gatekeepers imposing like de facto standards with interoperability? Is it the case, or is it just would it leave some flexibility, let's say, or so the ability to other alternative platforms to differentiate, so propose different services? And then another question is, it is a point which is raised sometimes. So if all the services are interoperable, and that we see that many consumers are already using the services of the gatekeepers, would this interoperability actually give these consumers the incentive to use another service, or would it actually end up with them using the same service because anyway it will be interoperable with other potentially competing service? So this is the first set of questions. And then the second one is about privacy and security. So Ian mentioned that so interoperability would not affect the end-to-end encryption, sorry. So to understand if there is like a service which is proposing high level of security and privacy standards, does it mean that there is a kind of lowering of these standards in case the different services which are not respecting the same high level standards in making these services interoperable? So does it have to be like, can each service maintain the high level of standards, or would it be impacted? So the floor is yours. So I don't know who wants to start. I know that on the privacy and security issues, there is also EFF and worked on a paper on privacy and interoperability. So I don't know, Christoph, if you want to start with this.
Yeah, sure. I think first we shouldn't make a mistake in the debate about privacy versus interoperability, because we don't believe that they are contradicting objectives. What we see is that current privacy problems are caused by the gatekeeper platforms, because it's gatekeeper platforms which do not respect user privacy. And we have a lot of well-documented cases about that. So the idea of competition and the DMA would be, hey, let's give users more power to decide how their information is shared and with whom. To give an option to users to simply leave a surveillance network instead of hoping that what Ian has pointed out, the lead DPA in Ireland is going to bring a case and end this misery for users. It's not going to happen. We cannot wait that the sector fixes itself, and that's why interoperability is so important. Interoperability mandate would give users actual options to break out of those data silos and choose an alternative platform that offers much better privacy. So this is why we understand interoperability as a tool that enhances privacy. And for this, we've published a white paper called Privacy Without Monopoly, which explains in much more detail why we can have true competition through interoperability and privacy. And I will drop the link to that paper in the chat. And I think it fits to the EDPS statement to the DSA and DMA. The EDPS stated that interoperability can help to address user lock-in and to create opportunities for better data protection. I think it's the same what we have with data portability. You have the option of first, better competition, and second, to enhance user privacy, to give users an actual right to self-determine the destiny over their data. What is clear is that an interoperability mandate will cause companies to share data that they otherwise would not have shared. And what we would like to avoid is to have in a competition instrument enabling competition in surveillance. So it's very important for us to make sure that users decide when and under circumstances to interact with another platform. So it's important to see the rules of the DMA or DSA, because we advocate for interop in both proposals, to be paired with the idea of the GDPR of achieving true consent, rules on minimization. Those things will be very crucial. Plus, we need scrutiny over platforms. So like interoperability interfaces, they should not be hidden. They should be easy to find, well documented and transparent. And I think all this can be achieved with the DMA. It can be achieved with transparency measures under the DSA. And once we do that, I think then we understand that interoperability will be the lever actually that users can be self-empowered to protect their privacy in a much more efficient way. And I will leave perhaps the security questions or encryption questions to Ian or other more capable panelists that are more educated on how to best describe it.
Please, Ian.
Let me give you a very brief, concrete example that explains why interoperability does not conflict with end-to-end encryption. You all use it every day. It's called TLS, when your little padlocks appear in your web browsers. This is an interoperable end-to-end encrypted channel that the data between your web browser and your web server is being carried over, and you don't have to be using Chrome to access google.com. Obviously, Google would not want that limitation. I use Safari. There are open source for software like Mozilla. They all support the technical standards that come from these bodies I mentioned earlier, the IETF and the W3C, and that enables interoperable, secure communications. Actually, the second and final concrete example I've given you is the one that the UK Competition and Markets Authority used in their report rejecting this criticism from some of the incumbents. They said, well, look, Facebook is making, it has already made Facebook Messenger and Instagram Messenger interoperable. It is planning to add WhatsApp interoperability. So it's already done it with 3 services. It just chooses as an incumbent, because it benefits from those network effects, not to open them up to competitor services. And that would be the role of regulation. How you precisely specify that process, I think the DMA has enough flexibility in the proposal from the Commission, because of course Article 6 obligations have to be further specified, and Vanessa and others have made important points about how that regulatory dialogue should happen. It shouldn't be left to the incumbent and the Commission. It should be multi-stakeholder. It should involve regulators like BEREC and BEREC's national regulatory authorities. And I think that's a perfectly good way to achieve this. It might be that the European Parliament and or the European Council feels they would like to put some more specifics in there, in Article 6 itself perhaps, and also in Article 7, and I think that would be a positive thing.
Thank you very much, Ian. I think that we are coming to the end, because we have only 1 minute. And we had many questions for you on ecosystems, dispute resolution, but we will leave it in just one final question. Is where do you see that we, national independent authorities, and not only the ones in BEREC, I mean also data protection authorities or any other, can help better in the DMA? In the dispute resolution, enforcement, participating in the process of designation of gatekeepers, defining that remedies, defining that where we can, do you think that we can help more With that, you are free to go to the next video conference if you have any suggestion.
Maybe I can.
Yes.
Maybe I can just quickly give it a go and open the floor for more in-depth reflection. I do believe that to regulate the digital markets in the way we would like to see them regulated, it implies different kind of skills and expertise and experiences. So one of the key points would be for the different authorities coming from different sectors to bring their added value to the discussion, being this in the moment of shaping the obligations or in a moment of monitoring or enforcing. So definitely a constant dialogue or exchange of experiences and opinions would help. Also because we're talking about a sector, an area that is regulated, that is regulated by different rules. These gatekeepers are subject to a number of regulatory framework, not only the DMA. They need to comply with the GDPR, they need to comply with the DSA, some of them, they need to comply with the Electronic Communication Code, a number of them. So there is also the necessity to make this process smooth and try to avoid any conflicting approach and decision, of course. So this is another aspect, but I do believe that we still don't have one. Possibly we're not going to have it for a while. One regulator that has the sufficient skills and experience to cover the entire DMA. So this is what I would recommend. Yes, that each of the regulators, they feed the discussion and the implementation.
Thank you very much. I was seeing Kay saying okay, no, or with the hand. So probably.
Vanessa.
Yes.
Vanessa.
Yes. Yes, Vanessa, please.
I would actually agree with what Isa just said. I mean, we believe that the Commission should be in the lead for enforcement, should be the one taking the decision in order to have harmonisation at the EU level. But we also see that there is a greater role for member state authorities, and by that, like Isa, I mean not only competition authorities, but data protection authorities, consumer protection authorities, other regulatory authorities, which could be designated by member states to assist the Commission in providing assistance in monitoring or investigation or implementation, also because they will have particular expertise and experience that may not be available at the Commission level, and there will be a need for a lot of good expertise to make sure that we get this law right. So there is definitely more scope, I think, for further involvement of others, as long as we maintain the position that the decision maker is at the central European level in order to ensure harmonisation and not have differing decisions across the EU, as we've seen in other cases in digital markets.
Thank you very much.
And this is very much in line also with the position of BEREC, where we talk about national independent authorities also to reinforce the idea that it's a cooperation actually of different skills and competencies coming from different approaches and different sectors. So it's something that BEREC is also very aligned on.
And thank you very much to all for sharing your insights. We could have been here a couple of hours more. So thank you very much once again for your time and for your knowledge. So with that, we give the floor to Michel, if you want to add anything.
Yes, thank you, Jorge, and thank you very much for all the panelists for these very interesting exchanges. I think we all have learned a lot, and we have very welcomed all your interventions. We couldn't answer every question because it's so fascinating, but it will be for another occasion. Many thanks again to Chiara and Jorge for having led this second session in an excellent way. And I wish you a very good afternoon. Take care and see you soon. Bye-bye.